Welcome to the to Beyond the Cart. I'm your host, Kyle Hamer, and in this episode, we're going to tackle a important topic because most e-commerce sellers think that legal issues are rare edge cases. That is until their listings disappear, their funds freeze, or a bad trademark shuts down their business overnight. In today's episode, we're going to talk about legal landmines hiding inside Amazon, Walmart, and other modern marketplaces, and how smart operators can protect revenue before enforcement hits. And I'd like to welcome my guest, Ken Ed. Ken, welcome to Beyond the Cart. We're excited to have you.
Thanks, Kyle. Good to be here.
Awesome. Well, this is not the most exciting in-demand topic unless you have one of these issues pop up in your business, and then it becomes the most pressing and important, all-consuming thing. And that is trademarks, IP, funds being frozen, and all of the craziness. Yeah, all that enforcement stuff. So, Ken, tell us a little bit about yourself, how you kind of got started in this, and a little bit about your company as well, the Amazon Sellers Attorney.
Sure. I've been an attorney for 45 years, so I was a little bit behind my back. But back in the early 2000s, my brother got involved in Amazon as a seller. And one day he found himself suspended. And the reason was they said that you were selling inauthentic products. And the funny thing about that was they were private label products. And he had the invoices for the products that he purchased from his manufacturer and had put in his own private label. But we had to write an appeal, and neither one of us had any idea how to do that. So I went ahead and wrote the appeal, got his account reinstated, and that's how I determined this is a great niche for me to try to work a business in, help other people. And that's how it happened.
Amazing. And since then, you've probably handled more than one appeal in your time.
There's been thousands, and now I've got a team of 10 that help me with them. Got another attorney who's a registered patent attorney who helps me with the IP stuff. And we haven't had a lack for business until AI came in and started doing stuff to our business.
Yeah, that may be worth a conversation here for sure.
Yeah.
I think at what point do most sellers kind of first realize they even exposed legally? Is it after something's already usually gone wrong that they've actually thought about it?
Yeah, after something happens. They either get a warning or they wake up in the morning and they have no store. They're done. They're cooked. So yeah, that's when it happens.
Is the most common that you get a warning, or what's like the most typical sort of use case or experience that sellers have?
The typical case a seller has is they don't get a warning. They get a notice that their account's been suspended. And they sometimes get a reason why, sometimes they don't get a reason why. And it's our job to go through their store and all the notices they've ever received, all the client complaints, which hide in reviews, they hide in returns, things like that. All the buzzwords that Amazon uses will be in those client complaints. And it's a kind of Amazon really doesn't have a priority to solve their issue right away. So it can take sometimes weeks, sometimes months.
Sure.
I've reinstated clients after 1 year. So yeah, it's pretty hairy.
Yeah, a lot of times I have clients or people have expressed this to me where they're like, why do platform enforcement systems sort of punish good operators as often as they punish bad operators? It doesn't seem like they use any sort of distinction to the process.
They don't. And now that they're using artificial intelligence more, a lot of these triggers for enforcement, in my opinion, they'll tell you, we reached this decision partly by algorithmic means and partly by human means. I don't buy that. I think that by and large, your triggering from enforcement is usually from mechanical means now, robotic means.
For sure. For sure. I mean, I think one of the things that absolutely, well, so think about it from Amazon's perspective as well. There's no way that they have enough people to manage all of the listing ASIN product. I mean, they have millions and millions and millions of products in their platform, and hundreds of thousands, if not millions of sellers at this point.
They have millions of sellers.
Yeah. So millions of sellers, probably hundreds of millions of products. There's no way that they have enough people to manually. So they have to rely on some level of like enterprise level automation to trigger some levels of enforcement.
They do.
I mean, just at the scale that they work at.
They do. And when you do get a human review, you don't get very much of it. I mean, you'd be lucky to get a few minutes. So you have to compose your case in a really concise way that hits on what they think you did. And you have to be very specific and bullet point your evidence and attach it. So, you know, because your reviewer is only going to give you a couple minutes.
Yeah, absolutely. So one of the sort of interesting trends, I think, in e-com when it comes to IP is the trademark troll.
Yes.
So what exactly is a trademark troll in e-commerce, and how are they exploiting the system today?
What they're doing, well, you see, a trademark troll is that you could be using a certain generic keywords to promote your listing. And you use those keywords in your title because that's how you get, that's how you get to the top of the page, the search page, among other things, as you well know. But these trademark trolls are trademarking terms that are common, that people use they're sometimes generic, sometimes descriptive, and then they'll come along and they'll wipe out their competitors with IP complaints. And they will usually, sometimes they will try, their end game is to completely get rid of their competitor, but sometimes they will use it as a blackmail tool, extortionary tool, and get you to pay some kind of license or something if you want to continue in business or if you want to continue to sell that product.
That's dirty. That's dirty.
Very dirty.
Is there any warning signs that sellers should watch out for that a trademark was filed defensively or in bad faith?
Not really. I mean, it kind of gets popped on you, but the best thing you can do is to protect your own IP. In other words, if you're selling a product and that product is a really popular product and it's doing well, they're going to be after you. That's where the trolls are going to come. They're going to look at you and say, we want to get this guy. And you've got to look at the terms you're using, the way you're presenting your product, and register a trademark, get into brand registry, and start protecting your own IP. That's the only way to really proactively prevent this kind of behavior.
Are there any avenues to sort of expunge weaponized IP?
Yes, you can. A lot of these times, these people aren't using the trademark. They're just registering a list of keywords, basically.
Got it.
And surprisingly, the Patent and Trademark Office is letting them get away with listing these descriptive keywords that usually you would say, look, these are not unusual. I mean, this is not Xerox. This is like,
generic.
A candy bar. You can't trademark candy bar. Well, they're trademarking these kind of terms. So you can do what's called an expungement. And that's a ex parte process where you tell the USPTO that this trademark's not really being used. And if the person who's weaponized the trademark against you wants to oppose that, they will. If they do oppose, they have to show proof that they're actually using the trademark, specimens, they have to show products, that type of thing.
Yeah, that makes a ton of sense.
The process, if they don't oppose, can take several months, and if they do oppose, can take half a year.
Wow. Yeah, that's pretty crazy. How often are patents used less as like a protection and more as an offensive kind of weapon against competitors?
Very often. But I have to say that also it's a double-edged sword, because you've got a lot
Sure.
of people sourcing stuff out of China where most of the stuff is manufactured. And
Hmm.
there's patent holders that have their ex factories making products for other people. And we
Yep.
have to use tools like Apex to try to get that eliminated. But on the other side of the coin, you have these people who are making these patents for products that already are in use. So it's really not a novel or new patent. It's something that's subject to a prior use. And this is the way we can attack it with reexamination, which is a little bit like expungement in the trademark arraignment.
Okay.
But it's just we make an ex parte application to the examiner, to the USPTO, that this patent has a prior use, and we used this patent way before. Like one case I had was a credit card holder. It was somebody who had a credit card holder, and which basically just was looked like
Hmm.
a credit card you stick your credit cards into. And my client had been using this thing before the person who patented the patent. So we were successful in getting it expunged or re-examined. We were successful in getting it knocked out.
No, that's cool. When does patent reexamination make sense, and when should maybe a seller walk away instead? Like, what sort of would you think are the determining factors to make that
The,
decision?
the determining factor is how important that product is to you. If it's just
Sure.
one of 100 things or 1,000 things that you sell, you should probably see what the walkaway point is, if it doesn't harm your account as a whole. But if it's a really important product to you, and you have actually been targeted by these trolls to try to knock you out of business, then you really have to stand on your ground and and eliminate it.
No, that makes a ton of sense. What mistakes do you see sellers make when they panic and maybe settle instead of challenging a weak or overbroad patent?
Yeah, I've seen that happen a lot, and now there's a trend happening in publishing and KDP publishing. So
Hmm.
but we're talking about patents, where I was talking about trademarks.
Sure.
Well, yeah. Can
Could
you
be the
repeat your
same.
question, Kyle?
Yeah, it's like, what mistakes do you see sellers make when they panic or they settle instead of challenging like a weak trademark or patent, or maybe challenging a patent or a trademark that's maybe or it's too broad, right? And they're just like, oh, I
Right.
can't do it because it's like already taken.
No, 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 no. If it's important to your account or your actual listing, and that listing's important to you, you have to fight.
Yeah,
Otherwise, if you back off, then they own you, and they can knock out your listing. They can threaten your account. If the analysis is, whether whether you did wrong or not, and if you didn't, and if your account health is impacted, then I think you have no choice but to fight.
yeah, for sure. Absolutely. What's the craziest patent case you've had to like manage? What's the most like absurd one? You're like, wow, this took either it was just crazy or wild or just took a weird turn.
Wow. Hard to say. Probably the RFID wallet.
Oh, interesting.
Yeah, and it wasn't a reexamination, but an Apex case where I had more than one client who challenged this patent. And the thing about the RFID wallet is that it was funded by a Kickstarter campaign. So I went back in the Wayback Machine. I found out when this first started with Kickstarter, and it was way past the point that everyone else was already doing it. So
Wow.
Yeah, it was that was the weirdest case I had, and it doesn't. I mean, patent cases are not really exciting. It's more exciting with the trademark, but that
Trademark
was the
realm.
weirdest patent case I had. Yeah.
No, that makes sense. What's the weirdest trademark? You said that's more exciting one. How often are those are kind of interesting?
The trademarks are interesting because they trademark really basic terms um, Scotch tape is Scotch tape, right? But if
Right.
you say adhesive tape, that's a generic tape,
Sure.
and they're trademarking adhesive tape, and they're trying to knock out every seller that
Sounds
has
generic.
that generic tape. So I've had a lot of those, especially like I mentioned before, very recently in the KDP field, because
Mm-hmm.
people will take a key term and put it in the title of their book, and then the
Yep.
troll will trademark that key term and try to knock out every book that in that particular subject.
Yeah.
So
Yeah. Yeah.
you can take something like the home apothecary for home remedies. This was one case I had where the trolls had trademarked all these terms, and everyone who had these books for years and years and years found themselves without their bestsellers.
Wow.
So
So what did you have to do? Did you have to get re-examination on that one, or you just challenged it?
no, we just challenged the. Well, there was one client who was brave enough to cancel the trademark, and then a lot of cases where we just challenged it in Amazon's what I call kangaroo court. See,
Mm-hmm.
Amazon has a kangaroo court, and that's where you present your appeal when you've been
Sure.
hit with an IP complaint. And some things like design patents, Amazon will think, and I've had arbitrations where the Amazon witness will say, yeah, we have a group that examines design trademarks and design patents and decides whether or not the product is infringing. And I asked them in cross-examination, well, what training do they have? Well, they don't really have any training. They just look at we they just look at it, and if it looks the same, then it's probably infringing.
It's probably
So
close enough, right?
yeah, close enough. So
Yeah.
yeah, so
I
a lot of
Googled it.
these, because my clients, unless the product is really, really, really important to them, they're just
Mm-hmm.
concerned about the health of their account, and
Sure.
they don't really want to invest in you know a proceeding like a reexamination or expungement, which is, relatively speaking, it's like $3,000. I mean, if it's an important
Yeah.
product, you got to do it.
Yeah. I mean, some of these products are making hundreds of thousands a month, right? So it's
Yes,
like I have
yes,
to. I'm every day that they're losing $3,000 a day when they're down easy
you got to
in
do
some
it. You
cases.
got to do
Yeah.
it. I had a client and this typically happens because trademarks are regional, right? So you got
Mm-hmm.
trademarks in the United States, you got trademarks in Europe, you got trademarks in Canada, and not everyone who will trademark their trade name in all these places. So I had a client that was selling vanilla. It was a Mexican vanilla out of
Mm-hmm.
Mexico, and they had a trademark in Mexico. They registered in Mexico. They had a trademark registered in Europe, and they didn't have a trademark registered in the United States. And one of their distributors decided, well, this is a great
Why not?
business. I'm just going to do this myself, and
Right.
trademarked their name.
Oh
And
man.
in that case, it had gone too long, um, because they kind of waffled on what they want to do. So we did what's called a trademark cancellation procedure, which is like a litigation.
Yeah.
And we ended up settling it, but I know in my heart I would have won that one.
All right. Yeah. No, that oh, man, it's such a good reminder, to be
Protect your IP.
proactive, protect your IP for sure. And
And it's not that hard to do. I mean,
mhm,
trademark filing fee is $350.
yeah,
I mean, you've got to do it, and you've got to join brand registry. Otherwise, going to knock you out of business.
Yeah, for sure. Is that one of the services that you offer? Do you get people with their IP and
Yes.
trademark stuff set up?
Yes, we do. And
Yeah, that's great.
we do beyond the, a lot of the trademark mills will say only $350 plus the filing fee, and we do thousands a day. Yeah, they do thousands a day, but once you get an office action, which is the examiner saying, well, what about this? What about that? We will follow through to the very end.
Right.
And they'll charge you
thousands a day.
money.
They're all garbage, but we do thousands a day, but it's all trash.
Exactly. Yes. So, we do the search, we do the registration, we do the response to the office action. And then, if brand registry sometimes will not allow a brand on, even though it's got a registered trademark. So we also do that.
Yeah. No, that's great. Some of the other services, obviously you help sellers with appeals and suspensions and all of that stuff beyond all of the IP stuff as well. And that is sort of underneath like policy enforcement at large. And why do you think that so many Amazon and even Walmart appeals fail, even when sellers think they've done everything right?
Well, one of the reasons why is it's not really clear what they expect you to do. Walmart is more clear than Amazon, what they expect you to do when you source a product. And Amazon is really deceitful in this area, because a lot of clients I've had in the past have been doing retail arbitrage, and Amazon doesn't prohibit that. They say sourcing from retail sources is fine, but if somebody complains, then they ask you present your invoices. That's the first glitch, because your invoices have to, your retail invoices have to have everything that a wholesale invoice has on it. And then the second glitch is they ask you to present your supply chain documentation, and people purchasing at retail can't do that.
This is my receipt that I got.
Yeah, big deal. It's not going to, so
receipt.
That's the issue. And a lot of people will source something from a wholesaler, and the wholesaler will say, yeah, we are authorized wholesaler for, let's say, Nike or whatever. And then when the seller gets in trouble and asks for these supply chain documentation, they'll say, well, that's a trade secret. We can't supply that. So my advice to sellers is, before you source the product, while you're in the process of vetting the supplier, look at the invoice they're going to give you and get a letter of authorization if you can, and get their supply chain documentation that shows that they're actually sourcing from the original source.
Yeah. Especially if you're buying from like a master distributor or something like that. It's not even the brand, right? Like they have to prove that they're in fact a licensed distributor of that brand manufacturer.
Exactly. And we get a lot of people who source from liquidation sources. Don't do that.
Yeah, that's rough.
Because you're not going to be able to document that with what they want.
I bought this for $1 in bulk from some random liquidation house.
From ABC auctions. You won't be able to resell that for long.
Yeah, for sure. What separates successful appeals and maybe even recovering some funds from ones that just sort of die in support hell?
Oh boy.
That's really the reality. Is you seem like it's easy to get in like this circular logic with support at times with Amazon.
The thing is, don't assume that you're going to be able to just make a knee-jerk reaction when you get a policy enforcement problem. Don't answer right away. Take the time to think it out. Try to figure out why they're doing this, what the causes really are. Examine the SOPs that you have in place, if you have them, for sourcing and things like that, or whatever the issue is. And call an expert. It's really worth it, because once you go ahead and write the first appeal, you want to make your best presentation first. And usually people don't. And that's how you get in the circular hell of, you haven't presented enough for us to reactivate your account. And it just keeps repeating and repeating, and it gives us a hard time too, because we'll come in and help you if we think you have a good chance. But if you've already made your own presentation or had someone do it badly, that's how you get into that problem.
Yeah, that makes sense. And like we mentioned it, like that's where evidence, the framing of your appeal, all of even legal posture potentially become an important aspect of how you're sending that information to that marketplace, right?
Yes, and one thing to remember is there's an unwritten rule that Amazon wants you to admit you did wrong and beg yourself back in. Well, that's not really the smartest way to do it. You have to really make, if you got nailed and you've got to say mea culpa, I did it, fine. But if there's any way out of it, you have to try to present it that way, because if you don't, and you're trying to collect your funds later, because we collect funds in arbitration all the time, the Amazon will come back and say, look, he admitted here in his appeal that he violated this the rights holders intellectual property rights. He admitted it. So it's a two-edged sword. You got to be careful not to fall on it.
For sure. And you mentioned this a little bit, but we talked a little bit about like automation and maybe stricter IP standards. And where do you see enforcement evolving at marketplaces like Amazon and Walmart over the next 12 to 24 months?
Oh, wow. I think 24 months is too long.
Too far out, right?
Yeah.
You're like, I'm just concerned about tomorrow.
Yeah, because this AI stuff is changing day by day.
For sure.
And,
yeah, 100%.
Amazon's spending millions of dollars on automated technology, and it's getting better and better. But it still hallucinates like all other automated technology. So it makes mistakes, and it traps innocent people in this web. And what it's looking for now is trigger words. Be careful what you use in your titles. Be careful what you use in your keywords. It's looking for all that stuff. And like I said before, if you've got any type of concerns of people who are returning products because of one thing or another, if they claim that it's inauthentic, this is a buzzword that'll get you enforced right away. So you have to be proactive with that in your communications with sellers, and make sure that they're happy. I mean, buyers, and make sure they're happy.
Yep. Yeah, for sure. Where I think more so today than maybe even previously is the importance, I think, of being proactive on the front end, like doing compliance checks before you even launch the product. Say you're a manufacturer, you're a brand owner, and you want to bring a new product to the space. What do you recommend as actions to take sort of preventatively before you even launch your product on a platform like Amazon?
Oh, I would make sure that I would take a look at who your competitors are going to be, and find out how protected they are, what their protections are, if there's any patented technology that you have to worry about. I would consult with someone like my partner, Michael Brand, who's a registered patent attorney, who can give you a full evaluation of where your product is at. And like I said before, make sure everything is IP protected before you even think about listing it.
Yeah, that's good. So I'll give you a scenario.
Sure.
So I have a client who is in the veterinarian space, and they want to launch a product in the US. They're in Canada, and we looked at their competitors, right? And wanted to use the same claims that they were doing. It's a pretty straightforward product, but we get obviously the automated EPA, EPA product, right? However, we look at their competitors, there's no EPA documentation. There's no EPA number listed on those products. And even they asked the people, asked those brands, yeah, we're not EPA registered for this product, yet they're listing just perfectly fine on Amazon. How do you recommend in that scenario where it seems to be like an imbalance where you have one competitor that seems to be cruising, not having any issue, and you have your listing that might be getting flagged or tagged by the algorithm.
That's a mistake a lot of clients will make, because they'll say that, everyone's doing this. Why did they get me? Enforcement is selective. It's not perfect. And there's, like you said before, there's literally millions of items listed, and Amazon is policing, but they can't police everything all the time. So you can't say, well, this guy didn't get busted. But on the other hand, you've got a lot of, in your client's situation, you've got a lot of products that Amazon may say, well, this is an insecticide. It's obviously not an insecticide, because, if it was a flea powder, that's an insecticide, right?
Sure.
But it's not a flea powder. I've had people have products that were not anything insecticide at all, but if they said that it controls bacteria or something like that.
Yeah, for sure. That's
controls
the
bacteria.
one that
Amazon will flag it as an insecticide, and it's not. Then you have to prove it's not. So it's an issue, and that comes under the restricted product category, where a lot of it is how you describe your product. Like if you got a product, if you got a supplement that's supposed to boost testosterone, you can't say it boosts testosterone. You've got to say that, it's helpful in, managing, your, body or something like that. But you can't make a claim that it actually does something. And a lot of people will get busted from what they say in their listings, because they're obviously trying to market it to a higher, audience.
Yeah, for sure. But dude, you got to follow FDA rules on that. They will bust you.
Labeling requirements you've got to follow, and this is where you should consult someone like us before you dive in. And mostly I see it when people already get into trouble. So then they start consulting. Us.
Exactly. that leads me to my next questions. How should operators proactively change their practice to stay ahead of these shifts and these automation, the increases in automation? Like, what do you think operators should do proactively instead of reacting, which is what we typically end up doing?
I think they should develop procedures, SOPs, standard operating procedures, like in sourcing, which is really, we talked a little bit before about this. It's really easy to do. You can basically go to an AI model, LLM, and have it write SOPs for you and just follow them. That's going to prevent a lot of these problems. And you should be taking you should have also, if you can afford it, I mean, sellers are in all different kinds of positions, but you should have a manager who reviews things like if you've got supplements, somebody who knows FDA labeling, somebody who knows the rules, to make sure that they're always there looking at these things before you list them, and being proactive while they're reviewing them from time to time to make sure that they're up with all the regulations.
Yeah, that's great. And that's something that your team helps people with? Yeah,
we help people with that. With that. But like I said, mostly they come to us after it's already too late.
Yeah, no. That's why they need to watch this episode and get their SOPs written and start thinking proactively about all things IP and compliance.
Absolutely.
Awesome. All right. Well, I'm gonna transition to a rapid fire. So I'm gonna ask you a series of questions, and you can just give me your immediate top of mind thought.
Rorschach test.
Yeah, exactly.
Okay.
What's the most dangerous legal assumption e-commerce sellers make today?
Wow, rapid fire.
I didn't say they were easy questions.
Yeah,
rapid fire.
The most dangerous legal assumption that they have the right to sell the product.
That's legit. That's a legit answer because they just assume that they can, right?
Yeah.
No,
Yeah. Or if their supplier tells
nailed
them,
it.
yeah, no problem, you got a green light, that you don't.
For sure. Well, I mean, I have a friend who bought a brand, a small one, little toy company, and he got his entire listings, everything shut down because one of the components in this toy that was packaged together was a trademark product. And they're like,
Oh,
yeah, you
yeah.
can't sell this product.
Yeah.
And so finally he kind of got permission from the original brand manufacturer to like license it
Wow.
and buy it directly from them and stuff like that. But it was
he was lucky. And
he was lucky.
sometimes there's a patented product that's hidden in there as well. So you got to watch out for that.
That was his thing. He got a patented product that was sort of in this bundle.
Yeah.
All right. What is one document or maybe series of documents every seller should have before they ever get suspended?
Invoices and supply chain documentation.
Yeah,
for sure.
You kind of already covered that one. So that was an easy one. That was a layup.
Yeah, that was easy.
That was an easy one. What's the biggest myth about fighting Amazon enforcement?
The biggest myth about fighting them is that you can, that you can't fight them, that you can't fight City Hall, but you definitely can fight the enforcement and say that you guys made a mistake. Because they often do.
They often do. Yeah. What is one legal risk that's growing the fastest, but still underestimated, maybe?
That's got to be IP infringement.
Yeah.
You know, you're at constant risk of that. And that's why I said be proactive and protect your own IP before someone claims it's their own.
Awesome. All right. So here's the last rapid fire question.
Okay.
If a seller can only afford to fix one legal gap this year, what should it be?
I'd say is sourcing. That's the most important now. That's what they're going after.
Yeah. Awesome. Well, you crushed all the rapid fire questions. So
cool.
Good job. Good job. No, that was awesome. Well, I appreciate you jumping on. This is great. Been great, Ken. And we'll have to follow up a little bit after we jump off because I have some other follow-up questions for you as well.
Okay, great.
But yeah, this has been awesome. So I'll wrap it up with this. If there's one takeaway from this conversation, from my perspective, it's that legal strategy is no longer a back office function. It's a core part of durable e-commerce businesses and how they're built today, right? Like that was my big takeaway. Trademarks, patents, appeals, enforcements, it's just not risk management. They're systems, to your point. You need to build SOPs so you understand, so you don't get trapped by them.
Absolutely.
And being proactive about it is critical in e-commerce today.
Yeah, agreed.
So with that, I would say thanks for everybody for joining. If there are any questions or anything like that, we're definitely we'll take some. If there's anybody that has some in the chat, you can dial them up. If not, if you're watching this, if this episode made you rethink how you're exposed maybe your business is, maybe you can share this episode with a partner or operator who needs to hear it. And Ken, what's the best way for people to get in touch with you?
Our website, www.amazonsellers.attorney, not .com, .attorney.
.attorney. We'll make sure that we have that.
We're on 24 hours a day, phone, chat, email.
Perfect.
Always someone will answer the question.
Awesome. And we'll make sure we include that in the comments too in the show as well. So with that, thanks so much, Ken, for joining
Thanks
us.
For having me.
It was great stuff.
Great. Thanks.
Bye, everybody.